Good morning, everybody. As you can hear by my voice, I am sick again like a dog. And I think it's from going out and taking care of all these snowstorms and everything. And my roommate ended up sick and he gave it to me. And I just started getting over my last cold. So please bear with me. I will be muting as much as I can so you don't got to hear me cough and sneeze. And I've got cough medicine and I got cough drops and everything on board here, so I'm ready. A lot of these just dropped late last night, so I wanted to go over the remaining parts of the transcript, but I just don't think I can get through 100 pages talking right now until a lot of the sneezing goes away at least. So, and my nose unclogs a bit, and then we'll go over the rest of the sealed transcript. I think we got to page 70 so far. Let me give some shout outs. Good morning, Nana. Good morning, Alicia. Good morning, Amy. K. Mitch. Oh, I'm sick as a dog. It's bad. I've got hopefully sometime this morning the pharmacy is going to be delivering some more meds for me. Regina. Oh, you are such a sweetheart. Oh, I sound like my son now. But thank you so much for that. What a good way to start. Yes, please don't forget to hit that like button on your way in. Okay, I'm going to bring up the first document, you guys, because there is some stuff that is really interesting that is still under seal, but there is 6 documents that we're going to see today that have been released, and there's information in there that we didn't know. But there's also, I wanted to go through this piece right here too that's on the screen, because there's stuff in here that makes me go, huh, okay. So this motion here, exceeding page limit, we will be going through that motion. It has been released. I have it up top here, so we will be going through that. But there is some stuff here that is sealed, like the subject document motion to redact or seal newly filed record. This is the 911 call. They're not going to release it. Good morning, Missy. I love you too. Yes, I've been really busy too, and I've been sick. I had just started getting over a cold, And then after the reads on Sunday, I did, because everybody on Sunday was asking for that read on Sophia. So I did, as soon as I was done the mini reads on Sunday, I did that read. Thank God I did, because when I woke up Monday morning, this is the way I woke up. So thank you so much for that, Miss Missy. Okay, so the 911 call. I'm living, Jean. Every day above ground is good, they say. I hope you are doing well. I'm sick, but I wanted to bring this to you guys. So, okay. Now, this one here, the motion in limine, okay? Look at this. Um, there is a motion here regarding the immediate family members in the courtroom. I can tell you what I think this is about. Oh, Pullman 30. I'm catching a cold right now. Oh my God, this one is brutal. And I want to thank you, I'm going to say Pullman because that's what it sounds like. PLLM 30. Really good insight in the comments, and I really do appreciate it. And Pullman also puts me on track when I have either mistakenly put something wrong or whatever. Very good insight. So watch for the comments from PLLM 30 in the comment sections, because some really good comments there. Really good. It's okay, K Mitch. I'm gonna live. I'm gonna live. All through COVID, I never got it. Never got it. And then it's like stupid little shit like this, and it's like, just cover your mouth when you cough. Wipe things down that you've touched when you're sick. Don't give it to everybody else, but it is what it is, right? Thank you, Jean. Thank you so much. Okay, so I'm going to tell you what I think this is based on what we're going to read. Let me get through these first, and then you will probably come to the conclusion yourself too. But the state is fighting it, I believe. There's a motion in limine that I believe that the defense filed. Subject document, motion to redact or seal newly filed record. Okay. Exhibit 1 to state's motion in limine immediate family members in the courtroom. I believe that they want to keep them out, and you're going to see why. Subject documents, motion to redact or seal. Sealed state's motion in limine improper death penalty comments. So if you guys have been following over on X and over on Facebook, Kaylee Goncalves' family has really said what's on their mind, put it that way. I know they made some comments regarding the firing squad. Now, these comments are coming, you got to remember, from parents of their beautiful daughter whose life was taken so brutally, okay? And when the state came out with the death penalty by firing squad, they had some stuff to say about it, okay? So I believe that now, I believe it's the defense that wants them out of the courtroom until trial. There's also here the sealed state's motion in limine regarding text messages and testimony. That's also probably from Kaylee's parents. A motion in limine the AT&T timing advance records. And a lot of these we're not going to get to see, but there's a lot of them that we are. I've got them already up top here and ready to go. A motion in limine, number 1, inflammatory evidence. Motion in limine 2, vague and undisclosed expert testimony. Motion in limine, use of term murder. Motion in limine using the term psychopath or sociopath. Now, I don't know if these comments here are the comments that were made by the Goncalves family, okay? Because they're all sealed. Motion in limine, Rylene Nolan in reference to touch and contact DNA. Witness identification by bushy eyebrows. Unnoticed 404B evidence. excluding Amazon click activity evidence at trial, improper expert opinion testimony, middlemen, a motion in limine to exclude the IgG evidence. Like, this is crazy, you guys. And we're going to see that the defense is about to file another huge motion. We're going to get to that. Motion in limine, make and model of suspect vehicle, conditions as aggravator, a stipulated motion to file defense exhibits in support of their motions in limine under seal. And these, you can see here, they are all sealed and they just dropped late last night. Okay. And here they are again, conditions aggravator. We just went over these. Vague and undisclosed expert testimony, newly filed record, motion to redact or seal newly filed records, motion to file defendant's motion in limine number 5 and number 14, inclusive data, and motion in limine statistical analyst under seal. Another one for inconclusive data, statistical analyst. Stipulated motion of the parties regarding investigator in the courtroom during trial. Stipulated motion to seal stipulated agreement and order. Stipulated agreement of the parties not to mention the 2014 phone incident. I don't know what this is. There is some phone call that happened in 2014 that one of the parties wanted to use, and now they've agreed not to use it. So there's a 2014 cell phone incident during trial. They've got a stipulated agreement, the parties not to mention it. Proposed sealed order on the parties' agreement not to mention the 2014 cell phone incident. I want to know what that is. Motion for leave to file additional motions challenging the death penalty. Here's the page, the motion to exceed page limit. We're going to see that. Motion to preclude the death penalty and adopt other necessary procedures due to the state's numerous disclosure violations. Notice to strike the death penalty. Here's where we get a little bit of information. Autism spectrum disorder. Okay? So, as the title states, mental illness. Are they going to try and use some kind of mental illness as a defense? And we get a little peek at it here because a lot of people don't know about this. I'll show you where to find this if you want to go and check it yourself. Autism spectrum disorder. Are they trying to say that Bryan Kohberger has autism? Right? Motion to redact or seal newly filed records. Stipulated motion to file defendant's exhibits in support of their motion to strike the death penalty re autism spectrum disorder. Subject motion to redact autism spectrum disorder again. And then we're going back into these were canceled because this was Judge John Judge. And then it shows you the hearings and everything that are coming up. So the next hearing is going to be April 9th. It's a motions hearing. Then there's another one on April 16th. And then a pretrial conference in June. Or May, sorry. So these are April. This is May. The jury trial that was supposed to happen in June canceled because that was with Judge John Judge. Another hearing scheduled for July. Another hearing scheduled for July, and then the jury trial starts August 11th. So a lot of people don't know where to find this here. But let me just show you quickly where you can find this. And then we'll get to the documents that were filed that we can see from what I just read you. Okay, let me just get it up here. Whoops. Okay. Okay, what am I doing here? Let me get rid of this. Stop screen sharing. And I'll screenshot this. Okay, so here is, like, look at this, you guys. This is the length. Here's where Bryan Kohberger starts. These are all the filings. Look at this. Like, you can scroll down forever. And then there's Lori Vallow. Okay, so if you go to the record on Bryan Kohberger, whoops, this is where you click on that right here. If you, instead of going into all the notices and everything, if you click here, that's where it brings up what I just read you here. You got to scroll all the way down to the end and then go back up. And then that's when you'll see all these pages here. And it's not showing. Anyway, you click on the case, hang on, and then it will bring up this. When you click on the case summary, it brings up these documents here. And what you do is you just scroll all the way down to the bottom because there's like 75 pages. Scroll down to the bottom, you guys, and that's where you'll see all this stuff here that we just went over. Okay, so that's that. Let's get rid of this. Let's get back to the documents. Okay, let me share a window. Here we go. Oh my gosh. I'm going to try and block out my mic as much as I can, you guys. Let me go full screen with this so you get me off of there. Okay, so the first document, let me get rid of that one. The first document that is filed is by the states. Let me just check chat here to see if there's any. I put a cough drop in my mouth too, so if you hear that hitting my teeth, I'm sorry. You're very welcome. Yeah, it's going to make a lot of people angry. I don't think the prosecution is going to go for a plea because for the defense, the plea is going to have to include taking the death penalty off the table, and the state's not going to do that. And again, for those of you coming in, I'm starting again with a major cold. I was just starting to get rid of the last one when I got this one. As you guys know, I rent a room to an old guy, and he got sick and passed it on to me, so I got it again. So please forgive me for the voice. Please forgive me if I've got to mute sometimes because you guys don't need to hear me sneeze, cough, or blow my nose, anything like that. I'm going to try and do my best. So in other words, the defense is scrambling for some sort of distraction not to take yes. Now we're going to go over, there's an alibi thing here regarding his alibi. There's all kinds of stuff here. We get a little glimpse of what is going to be happening. I think that the defense is trying to keep out, when they did the 360 of the house, they videotaped the 360 before they demolished it. I think the defense is now fighting to keep that out. Okay, so let's see what is being said here. Okay, state's motion in limine, admissibility of demonstrative exhibits and memorandum in support. Okay, so just by what they are saying here, I'm feeling that the defense is going to try and keep that 360. What do they call that? Where is PLLM 30? They know what this is called. You know that 360 camera that they do to take pictures of the house and the crime scene and all that? It's supposed to be to scale and all this stuff. That's what I think the defense is trying to keep out. And now the house is gone, right? Comes now the state of Idaho by and through Latah County prosecuting attorney and respectfully moves this court for a pretrial order regarding the admissibility of demonstrative exhibits. Specifically, the state will seek to introduce a three-dimensional model of the 1122 King Road residence for demonstrative purposes to aid witnesses in their testimony. The state further submits the following memorandum in support of its request. Standard of admissibility. The trial courts are endowed with discretion over the use of demonstrative exhibits during trial. They state this case law here. The Idaho Court of Appeals has held an exhibit is properly admissible for demonstrative purposes when the exhibit supplements the testimony of witnesses or assists the jury in obtaining a better understanding of the facts in issue. And in this case here, Masters versus Dewey, the Idaho Supreme Court held it is established that the use of exhibits by a testifying witness in order to supplement or illustrate events is proper insofar as the differences between the events depicted and the events observed are explained by the witnesses and the exhibit is not deceptive. In State versus Hall, the appropriate test is Idaho Rule of Evidence 403, balancing test of probative value against the danger of unfair prejudice, distraction, confusion of the issues, and waste of time. A diagram offered for the demonstrative purposes need only be relevant to illustrate a witness's testimony. It does not need to be precisely accurate, not to scale. State versus Rodenberg, whatever that is. More recently, the Idaho Supreme Court has agreed to State versus Roman, finding that the use of demonstrative exhibits at trial is appropriate to aid the understanding of testimony that may otherwise be difficult to comprehend through words or gestures alone. Oh, yeah. Like I said, there's no way that house should have been down. It's okay, Kate. I haven't even checked my email yet, but I will, if you've emailed me regarding the painting, let me give me a few days because I'm fighting to even get through this, but I thought it was important to bring this to you guys. Okay, so the argument. In this case, the state anticipates introducing a three-dimensional model of the 1122 King Road residence. See Exhibit S1 attached. We don't get to see it at trial. This model creates a virtual walkthrough of the crime scene. Yeah, this model will consist of 3 levels, which can be removed by level to show the interior layout of the residence. The interior layout will depict wall and door placements. So they're not going to have any furniture, human depictions, anything like that. The model will be placed on a rolling table for portability within the courtroom. It can be placed out of the way when not in use. This model is being constructed by the FBI based on depictions, documentation, and measurements taken at the scene prior to demolition of the 1122 King Road residence. The primary purpose of this model is to aid the jury in having a better understanding of the layout of the residence, which is unconventional. It is. It's really weird the way this house is set up. And to illustrate where certain events occurred within the residence. The model will aid certain witnesses, example, law enforcement, surviving roommates, individuals responding to the crime scene, and crime scene analysts, in demonstrating the location of victims, location of witnesses, location of items of evidence, items related to their testimony, path of travel, etc. The state anticipates laying the proper foundation to establish the model accurately reflects the layout of 1122 King Road residence. The model passes the IRE 403 balancing test as the value is facilitating the jury in visually understanding where facts in the issue occurred at the crime scene far outweighs any danger of unfair prejudice, distraction, confusion of the issues, or waste of time. This model will merely aid witnesses. Testimony is not being introduced to establish a certain fact in issue, therefore is not hearsay under IRE 801. So it's not being offered for the truth of the matter asserted. The state requests the court issue an order allowing the state to use three-dimensional model. Look at this, allowing the state to use the three-dimensional model. Don't you think you should have got that before you agreed to destroy the house? In my opinion, I feel like this is an order you guys should have got before you agreed destroy that house. What if the court says, no, can't use it? So now your 360 camera technology stuff is not going to be used, and there's no house, right? To me, this should have been done. You should have got this court order to be able to use this during trial before that house was destroyed. Finding the model is relevant in order to aid witnesses in their testimony, provided that the state lays adequate foundation for the demonstrative exhibit. This should have been done, in my opinion, before that house was destroyed. What do you guys think? Okay. Gene P. What I understand is the 360 technology creates a virtual walkthrough. Yes, it does. But in my opinion, they should have got this order before they agreed to destroy the house. Okay, so here's the next one. State's motion in limine. Alibi. So as you remember, the state said, okay, well, if he has an alibi, we want that information. The John Judge gave them a certain amount of time to give the prosecution over that evidence. The evidence that they did give, the statement that they gave, wasn't enough, and they're going to say it in here. And the last I believe that we were at was Judge John Judge said, look at, you got to be more specific. You got to name specific places. You got to name where exactly he went and who might have seen him, right? And he gave them a certain amount of time to do that, and they never did, right? So the state filed a motion in limine regarding the alibi. It comes now the state of Idaho by and through Latah County prosecuting attorney and respectfully moves the court in limine for an order prohibiting the defendant from presenting any evidence, whether by direct or cross-examination, in support of any claimed alibi other than from the defendant himself. So if you want to use this alibi, if you want, because you've given us nothing more, you didn't meet the deadlines and everything else, if you want to try and use some kind of alibi, you got to put the defendant on the stand, right? In support of any claimed alibi other than from the defendant himself, which means the defendant would have to go on the stand. By way of background, the state refers to the court to the following. The state's May 23rd, 2023 request for discovery disclosure, the alibi demand. July 22nd, 2023, which is like a long time ago. Motion to compel, notice of defense of alibi, or alternatively to bar certain evidence. Then August 2nd, objection to the state's motion to compel, motive of defense of alibi, or alternatively to bar certain evidence. The attached partial transcript of the August 18, 2023, so that's like a year and months ago, right? Court hearing related to alibi when the then presiding Judge John C. Oh my gosh. Observed the defendant's proffered so-called alibi, not really an alibi, and that he will address the issue of alibi disclosure in a subsequent scheduling order. The August 22, 2023 scheduling order, which in paragraph 7 at page 2 addresses the deadline for the defense to comply with its statutory obligations for alibi disclosure. This scheduling order was subsequently vacated when the defendant waived speedy trial on August 23rd. The state's December 21 motion for a scheduling order, which in the second full paragraph on page 3 refers to the issue of the alibi. And then February 23rd, 2024, so a year ago, order setting deadlines in hearing, which in paragraph 1 sets an alibi compliance deadline of April 17th. The defendant's April 17, 2024 notice of defendant's supplemental response to state's alibi demand. April 26th, response to notice of defendant's supplemental response to the state's demand. That's when they said that it doesn't give enough information. Former presiding judge, John C. Judge, June 27th scheduling order, which is subsequent to the April 17, 2024 Alibi disclosure deadline, and which makes no further reference to Alibi. It has now been approximately 20 months since the state first made its request for discovery disclosure regarding the alibi demand on May 23rd, 2023. As the court file reflects, highlighted and above, the defendant has failed to comply with the requirements of Idaho Code 19-519 and ICR 12.1. The defendant has yet to specify the specific place or places at which the defendant claims to have been at the time of the alleged offense, and the names and addresses of the witnesses upon whom he intends to rely to establish such an alibi. As directed by the February 23rd, 2024, so a year ago, order setting deadlines and hearing, and as discussed in the state's April 26, 2024 response to notice defense supplemental response to the state's alibi demand. Oh my gosh. The defendant proffered April 17, 2024. Notice of defendant's supplemental response to state's alibi demand does not comply with the requirements of Idaho Code 19-519 and ICR 12.1, or with the specific directive of the court's February 2024 order setting deadlines and hearing. The defendant should be prohibited from presenting any evidence, whether by direct or cross-examination, in support of any claimed alibi other than from the defendant himself. Even were the defendant to attempt to comply at this point in time, the state is irrevocably prejudiced. It has now been over 2 years since the homicides occurred and since the defendant was charged, and it would be unrealistic at this late date to expect the state to effectively investigate and respond to any new or additional alibi-related disclosures. This is precisely the situation that caused concern for the Idaho Court of Appeals in State versus Hoaz, as well as the concerns of the United States Supreme Court in Williams versus Florida, where the court noted that ease with which an alibi can be fabricated. See, because they keep getting more information, they get more of what the state has, and then they can fabricate an alibi around that, right? I wonder if the jury would be able to make the 226-mile trip from Ada County to Laytown to walk through the crime scene. There is no more crime scene. They demolished the house. And I don't know if they're going to be sequestered. They may be. Yeah, they tore down that house and the state agreed. That's why I said in the last motion that we just read that motion should have been, they should have got that order that they could use this 360 technology first before they agreed to let the house be ripped down. So, okay, so the United States Supreme Court had concerns where the court noted the ease with which an alibi can be fabricated, and the state's interest in protecting itself against an 11th hour defense is both obvious and legitimate. The Supreme Court held the adversary system of trial is hardly an end in itself. It is not yet a poker game in which players enjoy an absolute right always to conceal their cards until played. We find ample room in that system, at least as far as due process is concerned, which is designed to enhance the search for truth in the criminal trial by ensuing both the defendant and the state's ample opportunity to investigate certain facts crucial to the determination of guilt or innocence. For these reasons, the court should issue an order prohibiting the defendant from presenting any evidence, whether by direct or cross, in support of any claimed alibi other than from the defendant himself. The thing is, with the other blood that was in the house, it was found on a handrail. We covered that in the last live. It was found on the handrail going from the first floor to the second floor. And they seem to have evidence that points that Bryan Kohberger never went down those stairs to the first floor. So it's really a mute issue. Okay, so the second one. So this is again from the prosecuting attorney, state motion in limine, alternative perpetrator. So here we get some more evidence. It looks like the defense is trying to put on evidence, or they're trying to bring this in that there could have been somebody else that did it. Comes now the state of Idaho by and through the Latah County prosecuting attorney and respectfully moves the court in limine for an order prohibiting the defendant from offering alternative perpetrator evidence or argument without first satisfying the court that any such evidence is relevant and admissible pursuant to IRE 401, 402, and 403. In support of this motion, the state refers the court and counsel to State versus Miser, where Idaho Supreme Court addressed the standard for assessing the admissibility of alternative perpetrator evidence. 148 Idaho 236. In Miser, the Idaho Supreme Court held that the Idaho Rules of Evidence adopted in 1985 implicitly overruled State versus Larson in Idaho 42 at 240. The proper analysis under IRE 401, 402, 403. Citing to State versus Self, Idaho 718, the Idaho Supreme Court noted the trial must first consider and determine whether the proffered evidence is relevant under IRE 401. The second step is to determine whether the probative value of the proffered evidence is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. Noting the Larson court was concerned that the defendant will attempt to admit evidence where the sole purpose is to infer that an individual other than the accused committed the crime. The Idaho Supreme Court stated, if the defendant proffers evidence which merely tends to mislead the jury that another person committed the crime, or the evidence is not relevant because it does not tend to make the defendant's involvement more probable or less probable than it is within the trial court's discretion to find the evidence inadmissible, mere inferences that another person could have committed the crime will most likely not be relevant, if relevant, will still be subject to the limitation provisions of IRE 403. In this case, the course of the investigation, literally thousands of tips regarding possible perpetrators were received by law enforcement. With the exception of information regarding the defendant, none of these tips were substantiated. The state submits that any attempt by the defendant to offer or argue an alternative perpetrator theory without evidence specifically connecting that person. Oh my gosh. Okay. I didn't see that you guys couldn't see the full page. Sorry about that. Where was I? With the exception of information regarding the defendant, none of these tips were substantiated. The state submits that any attempt by the defendant to offer or argue an alternative perpetrator theory without evidence specifically connecting that person or other than the defendant to the homicides will do nothing more than mislead and confuse the jury, and would also result in undue delay, waste of time, would be a needless presentation of cumulative evidence, and unfairly prejudice to the state. Under the Idaho Supreme Court's ruling in Miser, this should be prohibited. The state respectfully submits that the defendant should be precluded from arguing alternative perpetrator evidence without first meeting the relevance of admissibility thresholds. Okay. Well, the thing is, Gene, when the prosecution and defense agreed to let the house be torn down, this case was still in Latah County. It was still in Moscow. They had no idea that it was going to be moved all the way to Ada County at that time that the house was torn down. We haven't seen that in evidence yet, so we don't talk about anything that we have not been able to verify. So we're not going to get into a shit show here where, there was so much shit flinging at the beginning of this, blaming Kaylee's ex-boyfriend, blaming Maddie's boyfriend, blaming students, blaming people from um, uh, Ethan's party thing there. There's been so much. I only go by what I can verify information. So we don't know if those students came by and contaminated the scene. We don't know that yet because we haven't seen it. I haven't been able to verify that, so we don't talk about it. We only deal with facts here. And that's to keep us out of, Susan, I'm not trying to put you out there, but I'm just saying we do that here because I don't want to be drawn into all the drama. So we stick with verified information here. Okay, let's go to the next one. This is again from the prosecution. And here we go. This is where we are starting to find out a little bit of information. Like I showed you at the beginning, something about a mental health issue. Maybe about Bryan being autistic, right? We've seen that in the first documents. If you're just joining now, you can scroll back to the beginning and we go over that in the case summary where the defense is talking about him being autistic all of a sudden. Okay. The things that we had heard about before that can be verified is he apparently had this visual snow, right? I didn't get in deep about it because whatever, visual snow. I mean, it can't be proved whether somebody has that or not. So, did he look up things that can't be proven? You know what I mean? And try to, use things that can't really be proven. Hang on, I gotta sneeze, you guys. Sorry, it usually comes in threes. That was one big sneeze. Susan says, no, none of that, Susan, has been proven. It's not fact yet. It hasn't come out yet in documents or anything. But Susan says, isn't it strange how everyone looks guilty? Same with the Ramsey. Yeah, I started seeing a lot about this, the Ramsey case taking flight again. So it's interesting for sure. Okay, so let's get into this one here. Neuropsychological and psychiatric evidence. Hang on a sec, you guys. I knew two more were coming. Anyway, okay. So the neuropsychological and psychiatric evidence. In the last documents that we went over with the transcript, the sealed hearing transcript, there was something brought up about his mental health. So are they going to now try and claim that he is suffering some mental health issues because nothing else is working, right? I don't know. Let's get through this document and let's see. I haven't read through all of these yet, so I'm reading along with you. Comes now the state of Idaho by and through the Latah County prosecuting attorney and respectfully moves the court for an order in limine prohibiting the defendant from offering testimony regarding neuropsychological evaluation and psychiatric evaluation of the defendant as summarized in the defendant's January 23, 2025 supplemental response to request for discovery regarding expert witness. So, do they have a witness that they want to bring in saying that he's suffering from some kind of mental illness? Specifically, the state objects to the proposed testimony of expert witness identified in Defendant's Exhibit D7 and D13, append to defendant's supplemental response to request for discovery regarding expert witness. In support of this motion, the state respectfully refers the court to Idaho Code 18207, which provides that a mental condition shall not be a defense to any charge of criminal conduct, except expert evidence on the issues of any state of mind, which is an element of the offense. Right? Is he going to claim that he was insane or something? I don't know. In each of the witnesses' summaries, Defendant's Exhibit D7, D13, the defendant specifically states the testimony is not intended to be a mental element defense pursuant to Idaho Code 18207, but rather, his testimony is about his state of mind as well as factual defense testimony, anticipated testimony elicited by the state. As such, this proposed testimony falls outside of the mental condition evidence allowed under Idaho Code 18207.3. Well then. Next one. This is going to be from Ann Taylor. Give me 2 seconds, you guys. I'm so sorry. This is the second last one. The last two are very short. Students coming, okay. GP says you're right. It's a shit show from the jump. Yes. I don't know if they're wanting a mental health evaluation, but I think that they are going to bring in an expert that says that he has some kind of autism and whatever else. We don't know because so much of it's sealed and we only get little tidbits that come out like this in these documents, right? So we got to remember documents that we've seen, documents that were in that sealed, or the discussion that was in the sealed hearing that we now have the transcript for. So you put 2 and 2 together there and then put those 2 and 2 together with this. That's what I think is going to happen. I said it way back in one of, probably over a year ago now, when I said, you watch, it's going to become a mental health issue. You watch. So we'll see. I agree, Nana. Okay, so this one's from Ann Taylor, and she's staying true to form. She learned her lesson, so we got to give her credit where credit is due. The judge had said, remember when she filed that 1,000-page motion? And the judge says, oh, hell no. There's limits. And if you want to go outside of those limits, you got to request that from the judge, right? So she's learned her lesson. But here we go. Motion for leave to extend page limit. So it looks like we're going to have at least another 80-page document. And I say that, you'll see why in the next document, why I say it's going to be 80 pages. And she's going to make sure it's 80 pages. Okay? Comes now, Bryan C. Kohberger, by and through his attorneys of record, and hereby requests the court for an order to allow the defense to exceed the 10-page limit for their motion in limine. Okay? So she's got several motions. It should be motions in limine. One is improperly disclosed expert testimony. 2 is Raylene Nolan and reference to touch and contact DNA. The next one is regarding witness identification, bushy eyebrows. The next one is conditions as an aggravator. This motion is made pursuant to Idaho Rule 8.3 of the local rules, blah, 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 blah. So there's 4 different things that she wants to touch on, okay? That she wants a motion on those 4 things. So the judge answered her, and he said, the court having before it the defendant's motion for leave to exceed page limit and good cause appearing now, therefore, it is hereby ordered the defendant's motion in limine improperly disposed expert testimony, Raylan Nolan reference to touch and contact DNA, motion in limine witness identification, bushy eyebrows, and the motion conditions as an aggravator may exceed the 10-page limit. But what he wrote right here, okay, we can't highlight it. Total pages may not exceed 20 pages per motion. She's got 4 motions, and they cannot exceed 20 pages each. So 4 times 20 is 80. She's going to use all 80 pages. I guarantee you, right? So that is the last of the documents that came in overnight. Like I said, give me a couple days to start feeling a lot better. Like right now, my head is pounding, my throat is so sore, but I wanted to bring you this document and these documents because I think they're important, right? I think they're really important. So we got through them. Thank the good Lord. Thank you, baby Jesus. If anything else comes out, I will bring them up. Now, if this cold starts getting worse where I can't talk, what I'll do is I'll just bring them up and go through them slowly and maybe highlight things that I want you guys to focus on. That's if I can't talk, but like my throat is killing. So, visual snow is a sign of schizophrenia. I've never heard that. Let's see. Let's look that up right now. Let's get rid of all these documents. Hang on. I'm going to look that up right now. Is visual snow a sign of schizophrenia? Visual snow syndrome, VSS, is a neurological condition that can cause static-like disturbances in vision. It's not a direct sign or symptom. Okay, so this is what I mean, Susan. I'm going to remove that. And this is what I mean by we don't put things in chat that we don't know 100%, because I'm going to show you this right now. Okay? Why is this? Let me get this smaller. Right here. While visual snow syndrome, VSS, is a neurological condition that can cause static-like disturbances, it is not a direct sign or symptom of schizophrenia. Schizophrenia is a mental disorder characterized by disturbance in thought, emotion, and behavior, while VSS is a neurological condition with both sensory and psychiatric aspects. That's why they're talking about that doctor. We just read a motion regarding this. So this is why I say I don't want things put in the chat that I have not verified, because it is not a direct sign or symptom of schizophrenia. There it is right there. Okay, so let's stop sharing that. Yeah, I did not. No, it's not. It is not. Visual snow is not a sign or a symptom of schizophrenia at all. Gene P says, my brother was diagnosed years ago with schizophrenia, so I'd like to know more. Well, I'm telling you, visual snow is not a symptom of schizophrenia. So if you want the more detailed, Visual snow is a neurological condition where individuals experience persistent visual disturbances, often described as static or snow-like patterns in their field of vision. The underlying cause of VSS is still not fully understood, but is believed to be related to a malfunction in the brain's visual processing. VSS can be associated with other conditions like migraines, epilepsy, and anxiety. Some people with VSS may experience psychiatric symptoms like anxiety, depression, or depersonalization. Whereas schizophrenia is a mental disorder that can cause a range of symptoms, including hallucinations, disorganized thinking, and difficulty with social interaction. So they're two very separate things. So I had to put that out there because I don't want people thinking that visual snow is a sign of schizophrenia when it is not. Yes. And that's why I say this channel is fact-based. Fact-based. That's from the Cleveland Clinic. This is a clinic that specializes in these disorders. I would ask you, Susan, show me a source where it says that visual snow is a sign of schizophrenia, because they're two very different disorders. One is a neurological condition that causes static-like disturbances in vision. That's visual snow. Whereas schizophrenia is a mental disorder that's characterized by disturbances in thought, emotion, and behavior. Two very different things. Good to know. I'm relieved. Gene P. Yeah, like schizophrenia, it's a mental illness. It's like it's characterized by disturbances in thought, emotion, and behavior. That has nothing to do with static like snow patterns in their eyes. That's visual. Totally separate things. One's neurological and the other one is not. Disorganized thinking, problems with interaction, hallucinations, those are signs of schizophrenia, not visual snow. So I would put the task to Susan to show me anywhere she can find that says visual snow is a symptom of schizophrenia. Because I've just looked up 3 different sites now, Psych Central, Cleveland Clinic, and medicine.net, and all of them say that it is not a symptom of schizophrenia. Gene P says, so if they want to bring in his mental condition, would that include BK's alleged past illicit drug addiction? I don't know. It's going to be interesting, you guys. It's really going to be interesting. And we're starting to see really that how much more the prosecution does have, right? As we get closer to this trial, a lot more is going to be coming out, right? There's going to be, I'm expecting tons of motions to be filed these next couple of months because the final motions have to be in by April. So March, beginning of April, they have to have all their motions in. I forget what the dates are now, but let me just see if I got it on my calendar here. I'm not sure I put it on my calendar. No. Unless it's in April. Yeah, all motions have to be in, I believe, by the 3rd of April. So, and then they have the motions hearing on April 16th. Which is probably going to run for days and days and days and days because of all these motions that are coming up, unless they put in another date between now and April to hear motions. That's very possible too. My Crime Time says the defense will fight to keep out his drug use. Yes, absolutely. It's not a sign, Susan, at all. Let's drop it. They're two very different things. One is I can't even speak. Has to do with neurology. The other one does not. Visual snow is all visual. It has nothing to do with disorganized thinking, the problems with social interaction, hallucinations, disturbing thoughts, and that's schizophrenia. It has to do with your behaviors and emotions. Has nothing to do with schizophrenia. Has nothing to do with visual, unless you talk about hallucinations. But that also has nothing to do with the eye, in the eye. That's I can't say it. Neurological. Oh my God. It has to do with visual processing, nothing to do with disorganized thinking. So, okay, I'm done. I'm done. My Crime Time says Ann Taylor is very good at lying to the court and public by just twisting her word and leaving out context to the statement she is making. I knew she would get nowhere with her Franks. Good. Yeah. Well, see, I've said this all along. I've said just because Ann Taylor says something doesn't mean it's true. They can say whatever they want in these motions and this and that. They can claim whatever they want. Like she claimed this fake alibi. They can say whatever. What when it comes to matter is what is said in court, right? It's odd. It's odd. Usually, people who suffer from visual snow will have like migraines and stuff like that. Excuse me. Or people with migraines tend to have that. People with like glaucoma or problems with their vision to begin with would have visual snow. That's what that's about. It has nothing to do with schizophrenia or mental health like that. So, yes. So, thank you for that, Crime Time. So happy you think the same way. Then love this channel. Well, we love you too. We love you too. Okay, you guys, I am about to go on a coughing fit again, so I did get through it. Yay! If you have a like this, please consider donating to the channel. Even if you are on the replay crew, there's a little heart that'll be below the video. You can do a super thanks there. Super chats, there's PayPal. That's across the bottom of the screen there. It really does help, and it, you know, gets me motivated to get on here, sick or not, right? So what I'm going to do is, if tomorrow, you guys, I'm feeling a little bit better, if I can get through the rest of that transcript, that would be great, because I want to see what more is in there. I haven't read through it. Like I said, I've been really sick, so I've been just laying down and drinking hot tea with honey and stuff like that. So hopefully maybe tomorrow I can get through that transcript. If I can, you'll see. I'll give you guys about a half an hour notice that I'm going to be up and doing it. Anything with Gov or Orge is truth. Yes. Okay, so with that being said, you guys, I'm going to end it like I always do. Please take care of yourselves. Please be safe. Always be aware of your surroundings. If you guys got a cold or are sick like I am right now, please get better. I will be praying that you get better. I hope you guys don't have this cold that I got, because it's brutal. Anyways, thank you for you guys being here and going through these documents with me. Thank you to my mods for being here and keeping things on track. I really appreciate you. I love you guys till the moon and back. Until next time, take care.